Welcome to day 11, session 2 of the virtual school on IP. The topic for this session is IPR and protection of traditional knowledge, Indian perspective. Our speaker for this session is Mr. Rishabh Srivastava, who is an IPR attorney practicing in Delhi High Court. He has a great zeal for research with a keen interest in intellectual property rights. He has written various research papers and takes special interest in traditional knowledge, trademarks, etc. He has also been previously working with an IP law firm, Rahul Chaudhary and Partners. In his professional career, he has been advising on various issues related to intellectual property rights to clients across the industry. It is indeed an honor to have you with us in today's session, and we welcome you, sir. All queries
Thank you.
related to the all
Yes, sir, you
queries
can carry on.
okay, sir. All queries related to the session shall be answered during the Q&A round at the end of the session. Participants may type their queries in the chat box. Now, I would like to hand over the session to Mr. Rishabh Srivastava and would request him to make his presentation on the topic today. Over to you, sir.
Thank you all. I hope that you all would be having a great evening and you would have done a great learning of IPR till now on this virtual school. So, can we please move to my first slide? Okay. So, basically, this is a basic understanding of traditional knowledge. It is something which is being hereditary carried by generations and generations. And it's very important to preserve this knowledge and also to save this knowledge for the future references. And the basic function of IPR, as the intellectual property right, is to support innovation and at the same time it creates monopoly for that particular innovation or knowledge. So the intersection of traditional knowledge and IPR is very, very important for the general well-being of the community as a whole and for the welfare of the society. So the basic question which arises that actually what is traditional knowledge? Because there are many things right and left which can come into traditional knowledge. So what where WIPO has defined traditional knowledge is a knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming a part of its cultural or spiritual identity. So, if you see the basic definition given by WIPO, that traditional knowledge can be skill also, it can be the practices, the general practices or rituals which are being followed in the society. It can also know how that what are the basic knowledge of that particular person which is transformed one generation to other generation, and it should be belonging to one particular community so that it forms as a part of a culture or the spiritual identity. So if you see India, the Ayurveda can be one of the traditional knowledge which India holds. And not only medicinal property or innovation, even the dance forms or even the folklores, these will be considered as traditional knowledge. And why traditional knowledge is and cultural conservation is very important. The one word simple answer for this is sustainable development. Because these practices are the indigenous practices which are developed in that particular culture, in that society. So the patterned according to the local needs of that community, of that region, and accordingly it helps for the sustainable development. Thus, it is very important that traditional knowledge is preserved. there should be well balanced between protection of traditional knowledge and access to that traditional knowledge to the Indian people. For example, everybody know what is the therapeutic value of neem. But today, if foreign company comes and it says that, okay, I have done a little bit of innovation in the therapeutic value of neem, and now no one other can use this antibacterial product. But this is not possible because neem and its medicinal property has been taken into consideration, has been practiced in every home of India. So eventually it creates a lot of problem for the people if access to these traditional knowledge is not provided to them. And sometimes this can even go higher level. For example, if there is a medicine which is developed by a particular community or a tribe, and generally these tribes or these community are not well know, they do not know well about their rights, they do not know how to commercialize it. So what happens if we come and actually takes that particular medicine and commercialize it and states that this is something which is coming from that company research, and gives no credit to those particular community, and even going one step further, if that community is using, or for example in Ladakh there is using that particular medicine, they're going ahead and suing them for the infringement of their patent. This can even create an identity crisis for the indigenous people and indigenous knowledge, that this is something which is developed by me, but it's been stolen by these big companies. So, can IPR protect such incidences? Or can IPR also help in conserving traditional knowledge? That's a big question, which we will be discussing further. Can we move to the next slide, please? So that's what I said, that almost all traditional knowledge in India, for that sake, are in the oral form or in written manuscript. And these manuscripts, as they have been traveling from ages to ages, from generations to generations, have become very old. Sometimes you cannot even find the record of it or evidence of it. Does it become very necessary to record all these rituals, all these practices, all medicinal products, and use it as evidence? Any add-on which is made in such traditional knowledge can be preserved or can be protected by the way of patents. And negative rights can also, like if any other person or any other company in USA wants to take a patent on indigenous knowledge of India, they can be stopped. We have evidence of it. Because in patent, an innovation gets the patent. If there is any prior art or previous knowledge is present, it will not patent. That's why it is very necessary that you evidence it, or it's very necessary that you create a record of that traditional knowledge which are present. And that's where the necessity of traditional knowledge lies. Can we move to the next slide, please? Right. And now coming upon economic perspective, that why traditional knowledge is holds such an important place in India and industrial sector. If you see that in a recent times, before COVID and after COVID. Before COVID, if you see that Ayurvedic medicines are there, and they have in last 5 to 10 years they have boomed up. And after COVID, that boom has become more. It has grown. Everybody knows that there is a kara which helps for boosting the immunity. Everybody wants to take it. There are the medicines coming in different pills and different forms. So Ayurvedic medicine industry has gone up. According to 2016 data, there were more than 8,500 manufacturers of Ayurvedic drugs in the country. Can you believe that how much big this industry is, and how and there's a lot of necessity to cater this industry. So how IPR can help these industries? See, now we have to look into two-way perspective. That the basic function of the IPR, especially the trademark law, is to play the role as a benefit of the consumers. For example, this particular source is coming from Himalaya, or this particular source is coming from Badrinath, or this particular medicine is coming from Dabur. So that is what an identification to the product is given to by the traders or by the IPR, while at the same time patents etc. also help. Patent is there, Biodiversity Act is there, geographical indication is there, which helps to protect this traditional knowledge. And to those marginalized classes who actually have developed this traditional knowledge, it helps protect that because it creates a wall between these industries and an indigenous knowledge of a tribe or the community. Can we please move to my next slide, please? So there have been a lot of international regulations as well as Indian regulations. This particular session is based on the Indian regulations, but I will tell you a bit about international regulations that what are there, which are actually used to preserve the traditional knowledge. So there is a Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklores, which was formed in 2009. This is very important that in traditional knowledge, even folklore is considered. Because what happens in today when the Bollywood industry is on a boom, or if you see that there's lots of industries, lot of movie industries in the regional languages are also coming up. And if they see a particular tribe performing special dance form or special folk form, they just cinematograph it and they use it in their movies. But this is something which is not the creativity of the filmmaker. This particular dance form belongs to that tribe and they should get benefit out of it. So that's why it becomes very important that folklores, dance forms are also included in this traditional knowledge. And there's then convention on diversity. Then there is a UPOV. Then there's Intergovernment Committee on WIPO. What is the work of Intergovernmental Committee of WIPO is to basically coordinate with all the states, all the nations which are there, and form a they aim to form a law or they aim to form a treaty to which is specific to for the protection of traditional knowledge. Because as of now, there is no treaty which only and only deals with traditional knowledge. So what this government committee wants to do is to create one such statute which can cover the traditional knowledge. Can we move to the next slide? So, what is actually the threats to the tradition which has been taken by WIPO? First is which I have been discussing a lot previously that unauthorized commercial exploitation. That people actually can commercialize the traditional knowledge without letting the local indigenous people know about that, right? Second is insulting and degrading culturally offensive use of material that is subject matter of TK. For example, I come and say that okay, if the use of turmeric or use of the kara, Ayush kara, is something which is very bad. It is something which is not very much useful, and it is actually garbage. So But if we have traditional knowledge, we have the evidences of it, we have the clinical trials for this thing, such traditional knowledge insult can be protected, right? So that's what, again, a threat which is present to a traditional knowledge. Again, third is that it false or misleading indications that there is a relationship with the communities wherein the material has originated. So, for example, I know that the kesar is grown very much in Jammu and Kashmir, and it has its own medicinal values which are not present in any other in any other state's kesar. So, what I do, I will go ahead and on my bottle of the kesar or the pouch of the kesar, I will write this is from Jammu and Kashmir. People buy, oh, this is from Jammu Kashmir, it would be a superior quality, it would be good for my health, it would be good for this. But that would not be the case. So it's very important that an misappropriate indication should be stopped. And that's where the Geographical Indication Act comes in, which helps to identify the product of a particular region. It gives a special certificate to it, right? And other thing is, the last is failure to appropriately acknowledge the source of the material. For example, like today I know that this particular spice is coming from Kerala, and it is something which is very good for the human beings. It can boost immunity at another level, and it belongs to that particular community. But eventually, I'm not acknowledging it. I'm not acknowledging it that it is produced from the Kerala, or it is coming from that particular community, or it is coming from that tribe. And why we are not acknowledging this? Because we don't want to share the revenue. And that's why traditional knowledge needs to be protected. Can we move ahead on the next slide, please? So, how it is protected in Indian IPR laws, as you know, that have the various statutes which protects. Each and every statute of India has the provision somewhere where the traditional knowledge is protected. Be it a patent act, be it a trademark act, be it copyright, or geographical indication goods, and protection of plant varieties and farmers like that. We'll be seeing all this in detail. Can we move to the next slide? Right. So now there comes the Patent Act 1970. So what it specifics is that an invention which is direct traditional knowledge or its components are derived from the commonly known traditional knowledge is not patentable. For example, I make a product which which again has the medicinal benefits, but it is derived from various herbs which you already know. It will not get the patent because that is something in knowledge which is already present into the society. Right. And there's another section 25, which is specially made because many times people do not acknowledge the traditional knowledge. What it says that if applicant does not disclose or wrongly mention the source of geographical origin of a biological material used for the invention, then it becomes a ground for the refusal. Right? So what it says that, for example, a medicine contains n number of products, or an invention contains 5 or 3 products, and they are the few products which are the biological material that they are taken from the nature. They are something which are not made in the lab. Then you have disclosed in the application that what is the geographical origin of this biological product, from where you are taking this. You have to mention it. If you do not mention it, your patent can be refused. So Section 10D of the Act specifies and it makes clear that any person cannot get the patent as if he is using traditional knowledge. Right? So it becomes very important that the patent system, when is actually merged with traditional knowledge, it again creates a field which is very broad and which depends upon the people's benefit also. Because if you see the BT original case, etc., there are many genetic changes which are being made in the vegetables. New hybrid vegetables are being made. So, what would happen to that particular invention? All right. So for this, the plant variety acts have been introduced, and even for that matter, these Section 10D etc. become very important. For example, if you just miss two breeds of the seeds and you say that okay, this is something which is newly invented, will not be taken because that seeds are existing within different community of the farmers. You have done just an addition of both the components. So that's how that traditional knowledge is protected by the Patents Act. Can we move to the next slide, please? Right. So how the Trademark Act helps it? So Trademark Act says that an mark or an indication which has become customary in the current language or is used in the practices of trade by everyone, you cannot get trademark over it. For example, if you want to get a trademark over the word knee, sorry, you cannot get it. This is something which is existing already, right? Also, any mark which consists of the indications or which may serve in trade to designate the kind, quality, intended person, value, and that's very important, that geographical origin or time of the production of the goods, rendering of the services or other character of the goods or services, these any words or marks do not get the trademark. For example, if I am writing Charak Sahinta's fever tablets, so Charak Sahinta is something which is traditional knowledge. It will not get the trademark. Or for example, I am saying that this particular seed is coming from its best, like it is this tea is coming from Assam, for example. So you cannot get the trademark over it because Assam tea is best, right? Anyone other person can also sell these. So that's how Trademark Act covers this traditional knowledge. We'll just take a minute of short break, and I would be just back in a minute. Yeah. So how Copyright Act helps in protection of knowledge? So the basic premise of Copyright Act is something which is eventually very helpful for protecting the traditional knowledge, because copyright subsists in original work, right? So it's very difficult to get copyright over traditional knowledge because traditional knowledge is not given by an individual person. It is something which is an collective knowledge of the society, right? And copyrights protect the ambit of the research work or research done on traditional knowledge. Thus, it helps traditional knowledge very positively. For example, I'm trying to make the new forms of the seeds, and for that I have to do the research. And thus, that research or a research paper would actually be covered by Copyright Act and it will be protected by the Copyright Act, right? It protects any court filings which are coming in, right? That's how the Copyright Act helps. Can we move to the next slide, please? So that's what I'm saying, that Geographical Indication Act is very, very important act for the preservation of traditional knowledge. As most of you would be aware about the basmati rice case, right? Where USA, even for that, the Neem case, where the USA has a company based out of USA has tried to get patent over basmati rice, as well as over the medicinal properties of the Neem. And at that time, basmati rice is something which is not recognized in India as something which is originating from this particular place. So what Geographical Indication Act do, it indicates or it acknowledges that this particular thing is coming from this area only. Like for now, there are lot of geographical indications are there. A lot of applications are being filed for the geographical indications. And basmati rice also has got a geographical indication for many states like Rajasthan, UP, etc. So that's what geographical indication helps to recognize that this is a traditional knowledge of this place, and no one else can take away that. This is recognized because that particular thing which is originating from a spatial geographical zone contains these special qualities. For example, if you see the case of the Kashmir or the apples of the Kashmir, the quality would be very different than the apples which are being grown in the northern part of the India, northern plains, because of the environment and weather. Thus, to maintain the purity of the traditional knowledge, Geographical Indication Act is very important. Can we move to the next slide, please? Right. So this is something which is very big done by the Indian government, and India is first country which has done this. And this is the brainchild of the India to preserve the traditional knowledge, and India has come to this particular traditional knowledge digital library, that is the making or digitalizing the various traditional knowledge in different forms of the databases, in the various forms of databases. India has learned his lesson by hard way in fighting out a long case in USA, and that this medicinal properties of the neem or the basmatis are already a prior art existing in India from many years. So after learning the lesson from that, India developed this, and that has been acknowledged by the even Indian judiciary. Justice V. Ramasubramaniam has said that as a matter of fact, one singular development, that is the establishment of traditional digital library by Central Council of Indian Medicine, shows that the under objects to preserve traditional knowledge acquired in Indian indigenous system. So what happens in this digital library, and not even after the success of traditional this digital library, TKDL, which is said, India has also formed various digital databases, and all the audience which are present here can get an access to the National Digital Library, where you can see any book which you want, which is digitalized there for free of cost. So that's what is the importance of digital databases in preserving collection knowledge. Because these digital databases acts as a prior art for the patents. They help to keep the traditional knowledge alive. That no one can actually get the patent because this traditional knowledge is already in existence. Can we move ahead on the next slide, please? So that is what TKDL is. TKDL is made by the Council of Science, CSIR, Council of Scientific and Industrial Research, Ministry of Science and Technology, and Ayush Department, and Ministry of Health and Family Welfare. These all ministries and departments of the government have come together to make this traditional knowledge digital library. What they have done, they have documented the knowledge available in public domain on traditional knowledge from the existing literature related to Ayurveda, Unani, and Siddha in digitalized format, and in 5 international languages: English, French, Japanese, Spanish, and German. So you can see what effort it would have been to actually digitalize all manuscripts which are present, going to different libraries, finding out the manuscripts, and then also converting it into different languages and uploading it. It was a huge exercise which had been taken by the government at that time to preserve what belongs to the India. Can we please move ahead to our next slide? So each shlok from the Ayurvedic text is turned into structured language using traditional knowledge resource classification. What they have done, they have made, like, for example, if anyone of you know about Trademark have 45 classes. For each of the class, there are different goods which fall into. The same way, TKRC is made, that is traditional knowledge resource classification. And 5,000 subgroups are made, ranging from medicinal to cosmetics to folklore. How the international pay classification has been made, according to that, these 5,000 subgroups are made, and these are then saved in that particular form in TKRS, so that if someone is doing prior art search, for a particular class in patents, then they can actually also get to know about the prior art which is existing in that patent classification. So again, this exercise has taken a lot of years to actually preserve and conserve the traditional knowledge of India, if not hijacked by the other countries. Can we move to the next slide, please? Right. And its access is given to different countries. The TKDL can be assessed by the European Patent Office, and European Patent Office was the first office to get access to it. After that, Indian Patent Office, then USPTO, that is United States Patent and Trademark Office, then Canadian IPO, that is Canadian Intellectual Property Office, German Patent Office, United Kingdom Patent Office, Intellectual Property of Australia, Japan Patent Office, Chile Patent Office, and Malaysia Patent Office. And they are still signing MOUs with the different countries to grant access to TKDL. So what happens now that if any trademark application comes into the Europe Patent Office or in United States Patent Office, they have their own softwares in which they can search that patent for any prior art search, which involves TKDL, that is Traditional Knowledge Digital Library. So if someone is trying to get patent on something which is already existed in India or in Indian traditional knowledge in Ayurveda or in any other forms, these officers, patent officers can get to know that this is something which is already existing and they cannot give or grant patent on that. So this way the whole traditional knowledge of India is being preserved. And this TKDL, after successful execution by the India, even China has made its own digital library. For that matter, even South Korea has made its digital library. So India has led the way in preserving its traditional knowledge by making digital databases. TKDL being one. Can we move to the next slide, please? So that's how the traditional digital library page looks like. However, the common public cannot actually access TKDL. That is one of the, I would say, uh, fault or the drawback, and which government should think upon, that even common should be given access to this digital library so that they can gain information knowledge. That's how the TKDL page looks like. I have given the link of TKDL in the chat. So it it says that around 2.5 lakhs medical formulations are available to the patent office. That's really a huge number of the medical formulas. It contains a special section for Ayurveda, for Unani, and Siddha. Right? Can we move to the next slide, please? So TKDL has 4 types of search options which are available to the various patent offices, which are the single search option, advanced search option, TKRC search, and IPC search. So single search is something which is like a Google search. A person can go ahead, type whatever it wants, and that will come on the TKDL. While advanced search is something which is like a Google search, like advanced Google search, wherever you can, actually go ahead and segregate the results by the country. You can go ahead and segregate the results by the various medicinal properties. While TKRC search is, I have already told you, traditional knowledge resource classification. There are the 5,000 classifications which have been made. You can go and search any classification which you want, and that is called TKRC search. That make more easy for the patent offices to search according to the requirement. For an example, if someone is trying to get a drug patented that is of cancer, here the person can go in the TKRC, search for the drugs of cancer and can actually search in it. And after that, an option was added that was IPC search, that is International Patent Classification Search. So many times it might be a situation where a person is not aware about traditional knowledge resource classification, the 5,000 classification which have been made, especially the person who is using it internationally, be it in the USA office or be it in UK or in Japan. So for that matter, they can actually, through the international patent classification, they can search a formulation. So that's how India has made the TKDL a complete software to preserve the traditional knowledge of India. Can we move to the next slide, please? Right. So once India have seen that this is something which is very much good for preserving the traditional knowledge, it is something which is which can be accessed all over, which is something which is in public domain. Then India has made more other digital databases to preserve such traditional knowledge, which can be actually be kept all over again and again for the generations to generations. So first one is National Mission for Manuscript. I will be sharing all the URLs with you so that you can go and can see that what it is and how it is. So that's what is National Mission for Manuscript. What they do, that they digitalize every manuscript which they have, be it from any religion. Whatever book they will be getting it, they will be actually digitalizing it. So that's what is National Mission for Manuscript. It actually contains all the traditional knowledge which is in various books. After that, we have something which is called Down the Memory Lane. It is about folklores and the various dance forms which exist, various paintings which exist. For example, if some traditional knowledge, some traditional painting is there, some person who is actually making clothes or is a garment manufacturer, he comes and what he does, he print that paintings on their garments. Again, that will be violation of the rights of the indigenous community, which is preserving that painting from a long. And any right, to enforce any right and evidence that this is coming from this particular tribe should be there, or this particular community should be there. And when the paintings and the drawings are would be actually be such or of such nature that they can be destroyed very easily, it becomes very important to digitalize them. And as I have already stated that after that, there's a one that Tradition Digital Library, which was the first and foremost mission which has been taken by the Indian government. And then there is National Science Digital Library, which tries to actually digitalize each and everything present in India from ancient time about science. Any books which deals with astronomy, any books which deals with metaphysics, so all these things are actually being digitalized in National Science Digital Library. And as far as I can recall, this is something which is available for the public to access. And then comes Kala Sampada. That's again a form of preserving the Indian cultures, literature, especially poetry, various forms of story writing, various music and folklore. These all are preserved in this, which is called as Kala Sampada, which can be also accessed by the common people. And then come the Indian Institute of Science, where they have initiative called Vidya Mapak. And in this particular initiative, they digitalize each and every book which relates to education. So see what Indian government has done beautifully, that they have covered each and every sector. They have not left anything which is uncovered. So each and everything is covered by the Indian government in various kind of digital databases. After that comes the Nalanda Digital Library. As everyone knows, that Nalanda is something which is very old university which was present. There were a lot of old books which were there. So these are digitalized and preserved by the government in Nalanda Digital Library. Uh, it can be accessed at Nalanda nitc.ac.in. And after then, that comes the after traditional digital library. This is one of the largest mission which is taken by the Indian government is Digital Library of India. Anyone can make their account there and can have an access to n number of books, to ranging from various topics. This Digital Library of India contains the digitalized forms of almost 65,000 books, which can be accessed by anyone on their laptop easily by sitting in their comfort of home, which contains the books which are old to till date, because once this era has to be move ahead. So the present era will also become a culture someday, and for that reason, Indian government is still digitalizing the books which they can in Digital Library of India. So these were the digital steps which has been taken, databases which has been made by the Indian government, which eventually forms the part of a prior art search in Patents Act, or become an evidence when anybody is trying to get the trademark over the famous painting as their own logo. So that is what these digital databases help in preserving the traditional knowledge. Can we move ahead on the next slide, please? So that's what for today has been about the preserving about our traditional knowledge through digital databases with using IPR as a hybrid tool. So if you have any doubt, you can ask now in the next 10 minutes, or you can also email me on my email ID, which is in front of you. Thank you.
Thank you so much, sir, for such an insightful session. Now I proceed to Q&A session. If anyone from the audience has any question, please type the same in the chat box and we will put the same to the speaker. Also, you can raise your hand. We will unmute you.